Honorable Prime Minister of India, Sri Narendra Modi ji, Honorable Union Minister for Law and Justice, Sri Kiran Rijiju ji, Brother Justice U.V. Lalit, Sri S.P. Singh Baghela, Minister for State for Law and Justice, Chief Ministers and Ministers from different states, Brother and Sister Judges of the Supreme Court, Sri K.K. Venugopal, Learned Attorney General, Chief Justice of different High Courts, Lieutenant Governors, Judges of High Courts, Chairpersons of the Tribunals, Learned Solicitor General, Additional Solicitor General, Law Officers, Judicial Officers, Media persons, other distinguished guests, ladies and gentlemen, Namaskar. I am very happy to be taking part in the 11th Joint Conference of Chief Ministers and Chief Justices for two reasons. Firstly, because we are meeting after 6 long years. Secondly, among us, the public representatives, this is an opportunity for us to learn from your rich experience, knowledge and wisdom that you have acquired in public life. You are the live link with the people. In your own way, each of one of you is a great opinion builder. Those in public life often come across the grievances of people, including those relating to the judiciary. You are the best placed to enlighten us about the expectations of the people. It is your experience in the field that is going to help us to understand ground realities. I am eagerly looking forward to collaborating with you in identifying and addressing the existing challenges to improve the functioning of the judiciary. All of us are constitutional functionaries, and we abide by the constitutional mandate. The role assigned to each of us needs no reiteration. The Constitution provides for separation of powers between the three organs, clearly outlining their sphere of functioning, delineating their power and responsibilities. It is the harmonious and coordinated functioning among the three organs of the state that has preserved and strengthened the democratic foundation of this great nation over the last 7 decades. While discharging our duties, we all must be mindful of the Lakshmana Rekha. The judiciary would never come in the way of governance if it is in accordance with law. We share your anxiety and concern regarding the welfare of the people. However, at the head of the judiciary, Indian judiciary, I shall attempt to present a broader picture about the judiciary as a whole and highlight the issues that are affecting the system. The 140 crore strong population of the world's largest democracy is bound to test its judiciary. No other constitutional court in the world hears such a wide range of issues in which large number. The situation was foreseen by the first Chief Justice of India, Justice Hiralal Kanya, who had once said, I quote, "This court would be called upon to discharge its duties as perhaps no other court has so far been called upon to do so," unquote. I would like to begin with the identifying few contributing factors for docket explosion in the Indian scenario. If a Tahsildar acts upon a grievance of a farmer regarding land survey or a ration card, the farmer would not think of approaching the court. If a municipal authority or a Gram Panchayat discharges its duty properly, the citizens need not look to courts. If revenue authorities acquire land through due process of law, the courts would not be burdened by land disputes. Apparently, these cases account to 66% of pendency. It is beyond my understanding as to why interdepartmental disputes of the governments or fights between public sector undertakings and the governments end up in courts. If service laws are applied fairly in matters of seniority, pension and so on, no employee will be compelled to go to courts. It is well known and acknowledged fact that government are the biggest litigants, according to the statistics, it is nearly 50% of the cases. If police investigates properly, fairly, if illegal arrests and custodial torture comes to an end, then no victim will have to approach the courts. Abiding by law and constitution is the key to good governance. However, this is often ignored. The opinions of law departments are not sought in the rush to implement executive decisions. Lack of people, special public prosecutors and standing counsels and the government leaders in courts is one of the major concerns which needs urgent remedy. The decisions of the court are not implemented by governments for years together. The resultant contempt petitions are a new category of burden on the courts, which is a direct result of defiance by governments. Deliberate inaction by the governments, despite judicial pronouncements, are not good for the health of democracy. The judiciary is also confronted with the issues of the executive willingly transferring the burden of decision making to it. Although policy making is not our domain, but if a citizen comes to the court with a prayer to address his grievance, the courts cannot say no. At times, ambiguities in legislation also add to existing legal issues. If the legislature passes a law with clarity of thought, foresight, and with people's welfare in mind, the scope of litigation gets minimized. The legislature is expected to solicit the views of the public and debate the bills clause by clause, threadbare, before enacting a law. When I expressed concern about the passing of laws without much legislative scrutiny on the 15th August last year, I was misunderstood by some quarters. Let there be no doubt, I have the highest regard for the legislature and the elected representatives. I value the role played by each of them in our democracy, right from a ward member to a member of parliament. I was merely pointing towards certain deficiencies. Interestingly, my sentiments of law making in India were shared by none other than the Honorable Lok Sabha Speaker, Sri Om Birla, who reportedly a few weeks back, I quote, "Law should be made after thorough debates and discussions, incorporating the needs of the aspirational sections of the society," unquote. Based on these principles, one can safely summarize that often litigation is triggered because of two major reasons. One is non-performance by various wings of the executive. Second is the legislature not realizing its full potential. I am sure you will all agree with me that these are avoidable burdens on judicial system. On various occasions, I have elaborated on the complexities involved in these issues. I am aware that there are certain concerns with the judicial system also. With regarding to timely delivery of justice and pendency. Pendency is often blamed on the judiciary due to paucity of time. I cannot explain the same in detail now. But a keen look at the websites of the courts will give you an idea about the huge workload on judges. The number of cases filed and disposed on each day is unimaginable. The rising number of frivolous litigations in an area of concern. For example, the well-meaning concept of public interest litigation is at times turning into personal interest litigation. No doubt, PIL has served a lot of public interest. However, it is sometimes being misused to stall projects or pressurize public authorities. These days, PIL has become a tool for those who want to settle scores or corporate rivalry. Realizing the potential for misuse, courts are now highly conscious in the entertaining of the same. This conference is an occasion for us to introspect and contemplate solutions. I have been a strong proponent of Indianization of the justice delivery system. By Indianization, I mean increasing accessibility by molding the system to suit the needs and sensibilities of the Indian population. It is a multi-dimensional concept. It calls for inclusivity, providing access to justice, removal of language barriers, reforms in practice and procedure, development of infrastructure, filling up of vacancies, augmenting the strength of the judiciary, and so on. I am of the firm belief that judicial infrastructure, both in terms of personal and physical infrastructure, needs urgent attention. With the expanding economy and growth in population, the caseload is rising alarmingly. There is severe gap between the existing infrastructure and the projected justice needs of the people. The environment of some courts, in some district courts, is such even lady advocates feel apprehensive about entering courtrooms, let alone female clients. Courts, being temples of justice, should be welcoming and carry the requisite dignity and aura. To standardize and improve judicial infrastructure, I have been focusing on the creation of a special purpose vehicles, namely National Judicial Infrastructure Authority